welcome back to another episode of Courts This Week, your go-to source for the latest legal updates presented by LiveLaw. I'm your host, Ostika Das, and I'm here to take you through the most significant updates from the week. From the corridors of the Supreme Court to local judicial proceedings, I'll be providing you with clear and concise summaries that keep you informed and ahead of the curve. But remember, for a more in-depth understanding, do visit our website at www.livelaw.in. In today's episode, we cover Chief Justice D.Y. Chandrachud's retirement and major judgments from his final week, including a Constitution Bench ruling on Aligarh Muslim University's minority status, a decision upholding the UP Madarsa Act, and the liquidation order for Jet Airways. We'll also discuss the Delhi air pollution case, the Pune Porsche incident, a suo motu case on the tragic electrocution of 3 elephants in Raipur's Chukimar Forest Division, and much more. So let's dive into the headlines. This Friday marked the final working day for Chief Justice of India Dr. D.Y. Chandrachud, who bid farewell to the Supreme Court in a ceremonial bench session, concluding his 2-year tenure as Chief Justice and 8 years on the bench. Appointed as the 50th Chief Justice of India on November 9, 2022, Chief Justice Chandrachud's Supreme Court journey began with his elevation from the Allahabad High Court on May 13, 2016. During the ceremonial session held on Friday afternoon, the outgoing Chief Justice reflected on his journey, remarking, and I quote, "We are here as pilgrims, birds for a short passage of time, do our work and leave. None of us is important enough to believe that the court will not survive without us." Saying this, he expressed confidence in Justice Sanjeev Khanna, who will take over as the Chief Justice on 11th November. Justice Chandrachud received an enthusiastic farewell from the bar, with notable figures such as Attorney General R. Venkataramani, Solicitor General Tushar Mehta, SCBA President Kapil Sibal, and many senior and junior lawyers praising his contributions. Senior advocates Huzaifa Ahmadi, Siddharth Dave, Dr. Menaka Guruswamy, and others commended his commitment to ensuring fair representation and equality for women in the legal field. The bar also acknowledged his tech-forward approach, including virtual hearings, and his commitment to causes like the rights of marginalized communities and individuals with disabilities. Chief Justice Chandrachud's final week was marked by a flurry of activity. To quickly recap, the Supreme Court rules were amended, replacing the term summer vacation with partial court working days and reducing the summer break to 95 days, down from the previous 103. This is just one of the many reforms Chief Justice Chandrachud introduced during his tenure. Before handing over the reins, he also inaugurated the National Judicial Museum and Archive, as well as a newly renovated bar room for women lawyers at the Supreme Court. In addition, several key judgments were delivered by benches led by Chief Justice Chandrachud this week. So without further ado, let's jump right in. In a pivotal ruling, a 7-judge bench of the Supreme Court revisited the 1967 decision in S. Aziz Basha versus Union of India, which denied minority status to institutions created by statute. By a narrow 4:3 margin, the bench has overruled this decision, reaffirming that statutory incorporation doesn't necessarily disqualify an institution from minority status. The case examined several central questions, including the correctness of the S. Aziz Basha judgment, the impact of the 1981 amendment to the Aligarh Muslim University Act, which granted minority status to the university, and whether the Allahabad High Court was correct in citing Basha to rule against AMU's minority status and reservation for Muslim candidates. The majority opinion, delivered by CJI D.Y. Chandrachud, stated that the key criteria for Article 30 protections is who established the institution, not who administers it. The judgment clarified that simply because AMU was incorporated through legislation, it doesn't mean it wasn't established by a minority group. The court emphasized that the terms incorporation and establishment are distinct and that the university's minority origins should be understood in light of its historical background. Now, the question of AMU's minority status will be further examined by a regular bench with this new perspective. Justices Surya Kant, Dipankar Datta, and Satish Chandra Sharma delivered separate dissenting opinions. To read more about this landmark ruling, visit our website at www.livelaw.in. This week, the Supreme Court clarified an important principle under Article 39B of the Constitution, which calls for the equitable distribution of resources for social welfare. In Property Owners Association v. State of Maharashtra, the court ruled that not all private properties can be classified as material resources of the community, that the state must distribute equitably. Addressing a legal challenge to Chapter 8A of the Maharashtra Housing and Area Development Act, which allows certain properties to be acquired at 100 times the monthly rent, the court asserted that any resource's community significance should be evaluated by factors like scarcity, the nature of the resource, and its impact on public welfare. The majority opinion by CJI Chandrachud held that while some private resources might be converted to public resources in certain cases, this doesn't apply broadly to all private property. Justice B.V. Nagaratna partially concurred, categorizing resources as either state-owned or privately owned, while Justice Dhulia dissented, stressing the constitutional focus on addressing inequality. In another significant ruling this week, the Supreme Court clarified the scope of light motor vehicle licenses. A 5-judge constitution bench led by Chief Justice Chandrachud determined that anyone holding an LMV license is permitted to drive a transport vehicle with an unladen weight under 7,500 kilograms without needing additional authorization. This judgment provides relief for LMV license holders, allowing them to operate smaller commercial vehicles, which can include certain transport vehicles. The court addressed concerns about road safety, noting that there was no evidence that drivers with LMV licenses caused more accidents. Additional requirements for driving heavier transport vehicles will still apply to those weighing over 7,500 kilograms. The bench ruled that the 2017 judgment in Mukund Devangan versus Oriental Insurance Co. Limited remains valid, solidifying LMV license holders' rights to drive certain transport vehicles. Another constitution bench led by Chief Justice Chandrachud ruled that recruitment eligibility criteria cannot be altered once a recruitment process is begun unless explicitly allowed by the relevant rules. Speaking through Justice Manoj Mishra, the court held that recruitment starts when the advertisement is issued, and eligibility criteria set at that stage should generally remain unchanged. Any mid-process modification must comply with Article 14 of the Constitution, meeting non-arbitrariness and fairness standards. The court emphasized that placement on a selection list doesn't guarantee a right to employment, giving the state discretion to leave certain posts unfilled for valid reasons. However, if vacancies exist, denying eligible candidates would be arbitrary. This week, a constitution bench of the Supreme Court also ruled against clauses in public-private contracts that allow PSUs to unilaterally appoint arbitrators from their own panels to resolve disputes with private contractors. In this pivotal judgment, Chief Justice D.Y. Chandrachud and Justices Rishikesh Roy, P.S. Narasimha, J.B. Pardiwala and Manoj Mishra clarified that although PSUs may maintain a panel of arbitrators, they cannot impose the choice on private parties by requiring that arbitrators be selected exclusively from such panels. This decision, impacting numerous government contracts, brings the arbitration framework in closer alignment with principles of fairness and neutrality. Importantly, the bench specified that this new rule will apply prospectively, affecting arbitrator appointments made after the date of this judgment. In a key decision on the Uttar Pradesh Board of Madarsa Education Act 2004, the Supreme Court has this week upheld the Act's validity except for its provision on regulating higher education degrees like Fazil and Kamil. This legislation, intended to oversee madrasas across the state, faced legal challenges after the Allahabad High Court deemed it unconstitutional in March, asserting that it breached the principle of secularism. A Supreme Court bench led by CJI D.Y. Chandrachud along with Justices J.B. Pardiwala and Manoj Mishra has found that the High Court's reasoning was incorrect. The Supreme Court has clarified that a law can only be struck down on the basis of fundamental rights violations or if it exceeds legislative competence, not solely for allegedly undermining secularism. However, the court struck down portions of the Act that regulate higher degrees as they conflicted with the University Grants Commission Act. The bench explained that the Act, in its remaining form, facilitates academic excellence and permits madrasas to prepare students for various examinations, promoting inclusivity within the educational system. In a scathing directive, the Supreme Court this week reprimanded Uttar Pradesh authorities for unlawfully demolishing homes under a road widening initiative. In 2019, petitioner Manoj Tibriwal Akash's home was demolished in Maharajganj district with minimal notice, sparking a suo motu writ petition in 2020. A bench of CJI D.Y. Chandrachud and Justices J.B. Pardiwala and Manoj Mishra criticized the state's handling of demolitions, remarking that such actions cannot be undertaken without due process and condemning them as high-handed. Authorities argued that the petitioner had encroached on public land, but the court emphasized that no acquisition documentation was presented and that an NHRC report identified minimal encroachment. Citing the lack of proper notice, the court ordered an interim compensation of Rs 25 lakhs to the petitioner. Further, the bench directed the UP Chief Secretary to investigate the officials and contractors involved in these illegal demolitions and to initiate disciplinary actions. Amidst escalating pollution levels this Diwali season, the Supreme Court has questioned the Delhi government and police on their efforts to enforce the firecracker ban. With AQI readings reaching record highs of over 400 in Delhi and 315 in Noida, a bench of Justices Abhay Oak and Augustine George Massey called upon the authorities to outline current and proposed enforcement measures in affidavits. The Centre for Science and Environment recently reported that pollution levels during Diwali surpassed those of previous years, exacerbated by farm fires that spiked from 160 to 605 in just one day. Referring to the report, amicus curiae Aparajita Singh stressed that pollution from stubble burning jumped from 10% to 30% during Diwali. The court further urged the Delhi administration to consider an extended firecracker ban, potentially applying it to other festive occasions. Additionally, Haryana and Punjab governments were directed to report on stubble burning incidents in October, while the union government assured that draft rules for curbing pollution, currently in translation, would be ready in 2 weeks. The court set November 14 as the deadline for compliance reporting. This week, the Supreme Court considered a sensitive petition by the Kuki Organization for Human Rights Trust, which alleged that leaked audio clips implicate Manipur Chief Minister N. Biren Singh in instigating ethnic violence in the state. The bench, comprising Chief Justice D.Y. Chandrachud and Justices J.B. Pardiwala and Manoj Mishra, directed the organization to provide evidence verifying the authenticity of these clips. Counsel for the petitioner, Advocate Prashant Bhushan, claimed the audio captures the CM's admissions of incitement and protection for attackers. Bhushan argued that despite being submitted to the Justice Lamba Commission, no follow-up action has occurred in 4 months. Solicitor General Tushar Mehta, representing the state, contended that such claims should be addressed by the High Court. The Supreme Court allowed the petitioner to submit the tapes for review, marking a significant development as the ethnic conflict, primarily between the Kuki and Meeti communities, has continued since May 2023. Ahead of the Maharashtra elections, Nationalist Congress Party leader Ajit Pawar assured the Supreme Court this week that he will publish a disclaimer within 36 hours in major Marathi and other dailies, clarifying that the NCP's use of the clock symbol is a sub judice matter. This undertaking, made by senior advocate Balbir Singh on Pawar's behalf, follows an oral directive by the Supreme Court bench of Justices Suryakant, Dipankar Datta and Ujjal Bhuya in response to an application filed by Sharad Pawar's faction. The Sharad Pawar group has sought a restraint against the Ajit Pawar group from using the clock symbol in the Maharashtra Assembly elections, arguing that Ajit Pawar should obtain a new symbol for the upcoming elections. The controversy over the symbol began earlier this year when the court mandated a disclaimer in NCP's Lok Sabha campaign materials, indicating that the symbol's use is contingent on litigation outcomes. Last month, the Supreme Court reiterated this stance for the Maharashtra State Assembly elections and warned of contempt proceedings if orders were breached. In this week's hearing, Balbir Singh assured the bench that the party is fully compliant with the court's order, adding that arrangements have been made with newspapers to publish a fresh disclaimer. This week, the Supreme Court ordered the liquidation of Jet Airways, invoking Article 142 of the Constitution due to a peculiar and alarming 5-year delay in implementing its resolution plan. Overruling the NCLAT's prior decision, which permitted the transfer of Jet Airways' ownership to the Jalan Calrock Consortium without complete payment as per the plan, the Supreme Court has now directed the NCLT's Mumbai bench to initiate liquidation proceedings immediately. Consequently, the Rs 200 crore infusion by the consortium will be forfeited, and lenders led by SBI are entitled to encash the Rs 150 crore performance bank guarantee. The bench, led by Chief Justice D.Y. Chandrachud and comprising Justices J.B. Pardiwala and Manoj Mishra, had reserved judgment on October 16th. This decision to liquidate Jet Airways marks a significant turn in one of India's longest-running insolvency cases. For more details on this case, you can visit www.livelaw.in. In a significant ruling this week, the Supreme Court has allowed Directorate of Revenue Intelligence officers to issue show-cause notices under the Customs Act. This development comes as the Supreme Court reviewed and overturned its 2021 decision in Kanoon India Pvt Ltd v Commissioner of Customs, which previously restricted DRI officers' authority under the Customs Act. A bench led by Chief Justice Chandrachud concluded that DRI officers qualify as proper officers and can therefore issue notices under Section 28 of the Customs Act 1962 as well as conduct duty recovery operations. Next, the Supreme Court has denied anticipatory bail to Arun Kumar Devnath Singh, the father of a minor co-accused in the Pune Porsche car accident case. The tragic incident, which occurred in May, involved the minor sitting next to the main accused, who was reportedly driving at high speed, resulting in the death of two youths in Pune's Kalyani Nagar area. The Bombay High Court had previously dismissed Singh's bail application, citing his alleged attempts to tamper with evidence by bribing hospital staff to replace his son's blood sample with that of a co-accused. His effort was reportedly aimed at concealing the presence of alcohol in his son's blood. Senior advocate Siddharth Luthra and Vibha Datta Makhija argued for Singh, contending that only Section 201 of the IPC should apply and that the accusations have prejudiced the petitioner in a media trial. However, this argument did not find favor with the Supreme Court, which has now upheld the High Court's ruling and denied anticipatory bail to Singh. The Chhattisgarh High Court this week initiated a suo motu public interest litigation following reports of 3 elephants being fatally electrocuted by a low-hanging live wire in Raipur's Chukimar Forest Division. This tragic event, highlighted in newspaper reports on 27th October, added to the rising elephant mortality rate in the state, bringing the total to 78 deaths since 2001. The reports noted that live wires were left at just 3 to 4 meters above ground, far below the required 7.5 meters, and were non-insulated. In response, the division bench, comprising Chief Justice Ramesh Sinha and Justice Vibhu Datta Guru, directed the state's Energy Department and the Chhattisgarh State Power Distribution Company to submit an affidavit outlining the remedial actions taken. They also instructed the state to specify disciplinary measures against the officer responsible for leaving the live wires. And that's a wrap for this week's Legal News Roundup. But before we bid adieu, the entire LiveLaw team has a small request for our dedicated viewers. As an independent and fact-driven media organization, we are deeply committed to fearless and ethical journalism. To continue bringing you the latest legal updates, especially in this dynamic audiovisual format, we rely on your support. So here's how you can help. Give our video a thumbs up if you found it informative. Share it with your family, friends, classmates, and colleagues. Make sure you subscribe to our YouTube channel for more insightful content. Drop your valuable thoughts and feedback in the comments below and hit that bell icon to stay updated with our latest releases. Don't forget to visit our website at www.livelaw.in for our in-depth reports and analysis. Not only this, but the LiveLaw channel offers memberships for only ₹89 per month. Become a part of LL supporters today to access exclusive perks such as loyalty badges next to your name in comments and live chat, priority reply to comments, and for our student pass audience, early access to explainers and legal updates. I'm your host, Ostika Das, and it's been a pleasure bringing you this week's Legal News Roundup. Until next time, stay informed, stay engaged, and stay tuned to LiveLaw. Thank you for watching.